Good morning, everyone. Thank you for joining us today, the last in the series, insurance training series for this calendar year, 2024. You've got both myself and Keller joining or undertaking the last training session webinar today on Inquests. Just some housekeeping rules at the outset. This webinar is scheduled to last an hour. It is being recorded and we will be sending out the slides to the attendees. There is a session at the end, a question and answer session at the end, so please feel free to use the chat box to drop in any questions that you might have arising from the session. The purpose of the today's session is really to give you an overview as to the inquisitorial process. It is an area which has its own complexities and the case law is ever changing. So what Keller and I have decided to do today is keep it as simple as possible. Keller kindly is going to be dealing with the practical measures, and I will be dealing with some specific issues in relation to certain areas that may arise. So if we can just put the next slide, please.
Shall I introduce myself? Get cracking. Hello,
Yes.
everybody. My name is Keller Bowers. I am a partner at Forbes and head of the Social Services and Abuse Claims team. I work directly with both children and adult social care departments, both in relation to abuse claims and various other claims, as well as working directly with Ridwan on our inquest provision.
Before we start with your session, Keller, I thought it would be a good idea to test everyone's knowledge in terms of the inquisitorial process. So we've got a bit of a poll to run at the outset, and I think we're going to give everyone about 2 minutes, just up to 2 minutes to answer about 8 questions. So Hannah, if you want to run the poll at this stage.
So we will be dealing with all of these issues within the seminar that we're running today, but we just wanted to give you a flavour of perhaps some of the misconceptions, also see where your knowledge lies, and hopefully at the end when we give you the answers we will see some learning and growth around what we've done. So please give them a read, answer as many as you can within the time scale. Thank you. Anna, do you want to give us a heads up when it looks like everybody's had a chance to answer them? Okay, we're 70% complete, so we'll just give you a couple more seconds.
Right. In terms of the poll, we will come back to the answers. Thank you for completing that. So we will address the answers right at the end of this session. So, Keller, you're going to go first. And in what circumstances would a local authority be involved in an inquest?
Right. So as you say, I'm going to start off with the sort of practical on the ground considerations when you are asked to become part of an inquest. So the coroners investigate certain deaths which are deemed to be unnatural, violent, or where a cause is unknown. The coroner may request interested persons to provide evidence to enable the coroner to carry out their statutory duty. An interested person is someone who has the right to actively participate in the inquest proceedings. Now, there is a little bit of a misnomer here around the grammar. An interested person is not necessarily an individual, even though the wording would suggest that it should be an individual. An interested person can be a local authority, an institution, a business, an NHS provider, the police. So Greater Manchester Police could be an interested person, a local authority could be an interested person. And whether you want to be an interested person is also an interesting question. So the coroner may at the outset already have an idea of who they want to be interested persons within the inquest. That will come from the circumstances and facts of the situation that the coroner has been presented with. However, the coroner may also not know at the outset whether someone should be an interested person or not. If you've been made an interested person, then your position in the inquest is defined. And the reason you would want to be an interested person is that you get the right to actively participate. That means that you get all of the documentation from all of the other interested parties. You're able to put forward your own full documentary evidence. You're able to make representations at the inquest, ask questions of the other interested parties, and you can obviously be represented. So there is a benefit to being an interested party. However, you need to think carefully about that at the outset, because if your involvement is peripheral to the circumstances of the death, you may not wish to be an interested party or an interested person to the inquest, because that will direct the concentration of the coroner onto you potentially unnecessarily, or there's an additional cost because you then become involved in a lot more of the coronial process. So having that thought process at the outset is really important. And to do that, you need to be able to understand, analyse what the circumstances of the death were, and have a full consideration of what position you want to take in the inquest. The level of involvement that you may have in an inquest will depend on circumstances. And we've given a couple of examples here, which are directly from myself and Ridwan's experience. So I've dealt with a lot of inquests that involve social care involvement, either within a residential care home or related to the children's services involvement with a child on the child protection register. There's also road traffic collisions. So if you've got a death on the road, there may be a question around chevrons on the road, relevant signage, transient nuisances on the road, even flooding or something like that. And it may be that you'd be involved in that scenario. There's also employee or work-related accidents at work, falls from heights, accidents with machinery, things like that. So those are some of the obvious ones where you would be getting involved with the coronial process. Could I have the next slide? So how would a local authority, and we've concentrated this on a local authority, but the same principles apply no matter who the coroner is asking for information from. But how would a local authority be notified that they are involved in an inquest? Well, often the coroner's office will contact the first name that they're given within the local authority. Now, we say that because what happens is the coroner will receive a fairly limited amount of information at the outset of an inquest, and they may just be given a few names, either by the police or by the family, and they'll go directly to that person. It's important not to assume that the coroner knows exactly who they need to speak to, what information that they need at the outset. This is an investigation, an inquisitorial process, as Ridwan mentioned before. So the coroner is starting an investigation. Now, I've had several situations, I know Ridwan's experienced this as well, where a coroner's officer has gone directly to say a key frontline key worker and said, I would like a statement about your involvement with the deceased. That key worker has then given a statement to the coroner, but then there's not been a full analysis of the wider picture. We may need people at the directoral level. There may have been other people involved in that person's case at a more senior level. There may need to be people who can talk to the care plan. So it's important to have an escalation process, and I'll talk about that a little later on in one of the later slides. But it's important to know the coroner's officers also, they're under-resourced. They don't have the full information at the outset. So when you are notified, it's important to have a full review of exactly what the circumstances of the death were. And if the request from the coroner comes in to a key worker level, then it's important that internally you have an escalation process so that they know who to tell that they've been approached, who they can seek support from, how far up it may go. It depends on the circumstances. So it may need to go to director level. It may need to go to the insurance department and the legal department, so that everybody knows and there can be a coordinated approach.
Now, I was going to ask you about the importance of escalation.
Yeah.
Which obviously brings us on to the next slide, Hannah, please.
Yeah. So we've worked with a number of local authorities to actually help create an escalation process, which can be disseminated to a number of different departments, so that anybody within those departments, no matter who they are and at what level, if they get an approach from the coroner, they know exactly what to do. They know exactly who to tell, escalate it to management. Then the management of that department can escalate it to the insurance department, the legal department, the director level, to ensure that everybody's aware of it. Because, and we'll talk about this again in another slide, but it's really important that that person doesn't just do a witness statement into the coroner and say nothing about it and then find out 5 months later that they're being called to the inquest and then say, I need some help with a week to go. Because the coronial process, like every other court process, has directions, and there are things you have to do in a certain order and file with the coroner. And if you get to a point where you're a week before an inquest and then suddenly somebody needs some help and no one within the institution knew that this was happening, it's very difficult to unravel it the other way. So before, sorry, Ridwan.
One of the other important certainly disclosure. I know you mentioned earlier, you know, the importance of, or your status as an interested person, but one of the other factors of an interested person is being able to actually receive advanced disclosure from the coroner in terms of evidence that is before the coroner. So that's important as well, especially, I think, the bottom point there, in terms of a potential civil claim that may arise from the evidence.
Absolutely. There's 2 points to that. There is, if you get to a point where you are advised that a frontline key worker has given a statement and is being called to give evidence a week before, you didn't know that that was happening and you haven't had that consideration time as to whether you wanted to be an interested party, you're then going into that inquest blind, because you won't have had disclosure of all the other interested parties' documents. You won't know what they're saying about your processes. whether there's been any, they're saying there's any failure in the work that we've done as a local authority institution. So you're not fully prepared and on the front foot.
Yeah.
In terms of the sorry, Ridwan, did you want to say something?
Sorry, go on.
I was going to just say, just in terms of this process as well, that one of the we've worked on with local authorities is it can go through different channels. So it can go up to, it can be managed through information governance, it can be managed through insurance, it can be managed through legal. It depends what you want to do as an institution. But once it gets to that position, you know, if there is an intimated civil claim, it needs to be escalated and notified to the insurance department. And there's two reasons for that. The first is they are required to notify their insurers of any potential claim. And if they don't notify it and a civil claim comes in, there is a risk that the insurance policy won't be triggered because you haven't notified them of the potential. But also, if there is a civil claim, it can fall under your insurance policy and therefore you get legal support funding for that. So there's a benefit in it going through that process. When I say there might be a civil claim, also it's important to remember that that doesn't mean that there has to be a formal letter of claim received from anybody. The circumstances of the death are enough if we think that there is a potential for a civil claim for it to be notified through to insurance. Now, a lot of local authorities have in-house legal teams who have experience of dealing with inquests, and it may be through that escalation process that it gets to that position, and it's decided that the in-house legal team will deal with it, and that's completely legitimate. When we say here whether they've got the resources and expertise to deal with it, we mean obviously the legal team within local authorities are under significant pressure. There's recruitment pressure. They've got a lot of work that they're doing on the front line in relation to children's services, adult services, family court, court of protection. And these inquests, particularly if there's a lot of involvement and a number of interested parties, are very resource heavy. So it's really worth considering both that it gets notified to insurers. Second, whether you can benefit from legal fee funding as part of the insurance policy, and how much resource you have to do it internally, and experience, because the coronial process, again, is a separate set of regulations outside the civil procedure rules, the family court, and it's its own thing. So it's important to have appropriate advice on these various stages at the outset before you even get to the point of what an inquest will look like as a process.
Kelly, I want to ask a question, if you've finished on that point, regarding, obviously you mentioned witnesses providing evidence to the coroner. Mm-hmm. How does the duty of candour actually apply to the coronial process?
Yeah, it's interesting this, because there is a duty of candour currently, which is a legal definition and a legal requirement for the NHS and the police. There isn't one that covers absolutely everybody in the public services. But there's a difference between the legal duty candour as a legal definition and a general duty of candour as we understand it. It's really important in the inquest process to be upfront about any failings that happen. And there's two reasons for this. It's an inquisitorial, not an adversarial process. So it's not about allotting blame, but also there is an opportunity within that process to talk about how we've identified that things have gone wrong, what we've done about it, what action plan we have to put it back in place, and how we're liaising with other multidisciplinary bodies such as the police, the NHS, whoever it might be, around a better process. Now, the importance of that is that if you don't do that, and like Ridwan says, if you've got a witness who hasn't escalated this and you haven't thought through this process, and they're a frontline worker, and they then go to the inquest and are asked, right, what's the policy around this? How was the policy put in place? What's the procedure for X, Y, and Z? They may not be able to answer that question. Now, it's the coroner's duty to consider in all cases whether there should be a prevention of future death report. And Ridwan's going to deal with this in his slides in more detail later on. But essentially, that's the coroner saying, I've identified something that needs putting right to prevent any future deaths as a consequence. Now, that is public, and your response to it will be public. And if you'd had an opportunity during the inquest process to put all that information forward, you may avoid having one altogether. In terms of the duty of candour, the Ministry of Justice have actually issued guidance to their department regarding the duty of candour, and it's suggested that that guidance should be guidance to all interested parties in coronial process. And the Hillsborough inquiry has also suggested a new law of duty of candour, and that was actually mentioned in the new government's King's Speech. It's not yet law, but that will be for all public servants. So it's really important if you think something has gone wrong.
Yeah, I think the key.
We'll talk about it. We'll look at what's happened. We'll reflect on it, and we'll talk to you about, or you internally can talk about how you put it right and how you present that to the coroner.
Yeah, I think the government of kind of consultation on the subject has suggested a culture of a move away from being focused on blame and instead focus on safety, openness and transparency. So that's basically the government's line in terms of bringing in a law applicable to public servants effectively. So it will impact on local authorities predominantly.
And when we talk about at the end of the slide there, that it can attract negative press coverage and it needs to be handled sensitively, but also relates to the witnesses as well. If something's gone wrong, this is a really sensitive and emotive process. They're going to be in a court with the deceased's family. So it's really important to have thought through what those problems are, how it's gone wrong, and to be presenting clear evidence about how you're going to put it right. Often the family want to see recognition if there is something that's gone wrong. They want recognition, and a lot of them will say, I just want to know this won't happen to anybody else. So you need to be thinking in those ways when you're putting your evidence forward, which is why you need to think about a broad question of what is the coroner going to be looking at, what's relevant here, and who best within the local authority can deal with those questions.
Well, that brings me on nicely, Keller, to which witnesses are best placed to give evidence at an inquest.
Well, when we're talking, there's two parts to this. So there's those people who have had direct involvement with whatever has happened with the deceased. So that may be the social workers who've dealt with the Care Act assessment, or the care workers in a residential care home, or the children's social workers who've been directly involved with that child and the child protection, the child that's on a child protection register. And then there are those witnesses who can talk to what has happened, process, what has gone right, supporting those witnesses on the front line if that's the position, or talking about what's gone wrong and how we're going to put it right. So you will still need those frontline people to give evidence. Unfortunately, a lot of our clients, for really understandable reasons, will often say to us, well, can we just not get the director to give all of the evidence, because we're really worried about these frontline workers who know the person who's died directly, really upset by it. This whole process is very stressful. It's a very laudable aim to try and keep them out of that process. But unfortunately, in the vast majority of cases, that's not going to be possible, because the director's not going to be able to give evidence of what happened on a day-to-day basis. But what the operational management and directorship can do is deal with the organisational structure, the strategy, the process, the policies that were in place. So it's important to have those people there, both for that reason and as a support to those people who are on the front line. It's also really important from a pastoral perspective to provide those staff with appropriate support through that process. We recently dealt with an inquest where the frontline housing officers were actually involved not only with the inquest in relation to the death, but also in relation to a criminal trial where they were asked to give evidence. That's extremely stressful for people, one of which one of the people actually was off with stress during that period for very obvious reasons. It was very traumatic for them. We've got to remember that while these things are happening, although for us as lawyers, this is our involvement with it, for you as a local authority, there are frontline things that still need to be going on. There are people who still need to be protected. There are people who's frontline workers who still need to be out there working directly with the public. So we want to ensure that they're able to do that and feel supported throughout the process, because it is difficult. Could I have the next slide? Now, as I was saying, I've done all the practical things of when something comes in and you're first notified and you think, oh, what do we do with this? Some of the thought processes that need to be had about how much you're involved, who's going to be involved, how you're going to process it, and how you need to escalate it within your local authority or public body or whoever you're representing. Ridwan's going to deal with the procedural points of an inquest and what you're likely to expect in terms of the process.
Yeah, in terms of the purpose, really, the coroner essentially has a statutory duty under the Coroners and Justice Act 2009 to answer 4 statutory questions. And the questions are who the deceased was, how, when, and where they came to their death. Actually, most of you will think, well, we know who, when, and where. Those are quite straightforward questions when it comes to addressing those questions. The real nub of it is really the how question. And the how question comes back to what Keller said earlier in terms of this is a fact-finding exercise. And the whole process is inquisitorial and not adversarial. What do we mean by that? A criminal court or civil court, for any of you who have been fortunate to attend either jurisdiction, will know that you have either a claimant or a defendant, or the CPS or a defendant. And essentially you have a judge or a jury making decisions on outcomes. That doesn't apply in this instance within the coronial system. They have to simply address these statutory 4 questions, and it's essentially a fact-finding exercise. Within the rules themselves and within the Act, the last point there is it's not the duty of the coroner to actually establish civil or criminal liability. There is a but question, and I'll address that but later on when we're dealing with the different classifications and the conclusions. But one interesting sort of historical perspective, really, in terms of inquests, the Chief Coroner, His Honour Judge Teague, last November, on the 10-year anniversary of the 2009 Act, basically gave a speech. It's out there, it's worth having a listen to be honest, but he was giving a historical sort of perspective as to the coronial service. And believe it or not, in the 19th century, inquests were held in not a courtroom, not in civil courts, not in criminal courts. Actually, inquests were held in pubs. Who would have known that? So you had a coroner with the jury members rocking up to the pub and deciding those statutory 4 questions: who, how, when, and where a person came to the death. The other aspect with the inquest is it's meant to be local justice. So a lot of the coroners will have their own areas that they're dealing with. And coroners are actually removed from the actual national judiciary service. So they are generally appointed by local authorities, coroners or senior coroners and assistant coroners. But that's not to mean that they actually work for the local authority. they are simply funded by them. It's part of that overall service in terms of reporting a death, and it's part of that service that they provide. One of the other
I think it's important to say as well, in terms of who the coroners actually are, although quite a lot of them are lawyers,
yeah,
some of them are medically trained, some of them come from a public service background. You never really quite know who you're going to get. And what background they've come from, which is why it's important to never assume, because you understand what the process is and where the area that you're working in, that the coroner has any idea of how that works at all in terms of, you know, multidisciplinary working, who's responsible for what between a local authority and an NHS trust. You've really got to be spelling that stuff out and assume they don't know.
Yeah. Well, one of the final points on this slide that I would like to make is the chief coroner essentially during that speech indicated that it's key that the deceased at any inquest hearing is at the centre of the inquest. So the deceased family effectively. So it's a really important factor, and you will see that for many of you who have attended inquests, that the coroner does put the deceased and the family at pretty much the centre of the inquest process. Next slide, please. In terms of inquest classifications, this is a really big topic. It's a complex area of law. There are decisions from the Supreme Court that generally change the law or change the actual approach of how coroners should be dealing with inquests. But generally, broadly speaking, there are two classifications. You have a standard inquest, which is otherwise known as a Jameson inquest, and the how question, which tends to be the question which is the focus of the coroner. The how question means by what means the deceased came to his death. That's very much a narrower scope in terms of questions being asked. Standard inquests will generally be dealt with probably within the day, couple of hours or in the day. There may be a mixture of live evidence as well as written evidence as well. The second type of inquest that's applicable, that may be applicable, is what they generally term as Article 2 inquests. Article 2 is the the right to life under the Human Rights Act, and it's also known as the investigative duty or the Middleton inquest. That type of inquest is a lot broader. It's wider in scope. And so the how question is actually widened. So it's not just by what means, it actually extends to in what circumstances as well. Why is that important? Well, it actually brings out more detailed investigation. So Keller's touched upon about operational issues or systemic issues that may arise. An Article 2 inquest will essentially be more detailed in relation to those operational and systemic processes that an organisation may have in place. One of the main reasons or main differences in terms of the scope really addresses the conclusions that can be reached, and I'm going to deal with that in a later slide. But really at this stage, some Article 2 inquests are automatic, I should say. So, for example, Article 2 inquests may apply where there's a death in custody or the person is in police custody, state detention effectively. That's not the only reason. There could be, you know, those are automatic rights. But if there is also a failure to protect a person from a risk of immediate, where there's a failure to actually protect an individual, a deceased, from immediate risk to life, it may trigger an Article 2 inquest. And there are other circumstances that an Article 2 inquest may be triggered. For example, it's quite a wide discretion, where there may be an accident at work, for example, and the coroner wants to explore the systems and procedures in place. And so it could actually trigger that. So it is a wide area. The case law in relation to this inquest classifications changes. One of the key aspects in terms of Article 2 is really the last point on the slide here, is an Article 2 will generally trigger the entitlement of the family to be legally represented and be entitled to public funding as well through the Legal Aid Board. So generally, if there's an Article 2 inquest, it may well trigger the potential, certainly for a civil claim, that you need to be aware of. That's all, you know, certainly at this stage, that's all I want to really say in relation to inquest classifications. It is a massive topic. I could probably spend an hour just on inquest classification, going through the case law, and we don't have time today really to deal with that. One other aspect of inquests is, would a coroner hold a jury inquest? And certainly juries sit in Crown Courts during criminal trials. So certainly for anyone who sat as a juror at the Crown Court would be used to what responsibilities a juror would have at the Crown Court during a criminal trial. Well, the coroner can sit with a juror, with a jury, but there are certain circumstances which are laid out in the Coroner and Justice Act, where it's an automatic right, where a jury a coroner should summons a jury, generally death in custody, or where it's an unnatural, violent death as well in custody, where police, where there's an act of omission operated by the police. But the last point there is really a trigger as well. And I know Keller recently had a case where the coroner toyed with this area as to whether or not it was a notifiable accident. Essentially, if it's a RIDDOR reportable incident, so a health and safety reportable incident, an accident at work which triggers RIDDOR reporting requirements, that will generally trigger the requirement for a jury inquest. But the last point here is the coroner has a wide discretion in terms of, as long as a senior coroner thinks there's sufficient reason for doing so, that can trigger a jury inquest. From my own experience, many years ago, two separate inquest hearings, the coroner held a jury inquest in a fatality where there was a reversing a refuge wagon that knocked over a member of the public. In that case, the coroner decided to hold that inquest with a jury. The other circumstance where a senior coroner held a jury inquest was this was a local football club who there was a fatality with some goalposts which killed regrettably killed a, a young child who was during the summer break operating they took out some goalposts, and in that case the coroner also held a jury inquest as well. So that went outside the automatic scope. So that wide discretion is always available to the coroner in terms of holding a jury inquest.
Yeah, I think there's, like you were saying, the examples you were giving are similar ones. We've had one where a child who was on a child in need plan, but not in residential care, unfortunately committed suicide. So there was a question over whether they could be considered in state detention or relevant points were triggered. Jury inquest was called in that. In another one, an employee has died. It's been reported to RIDDOR, done a RIDDOR report. HSE have not wanted to investigate. There didn't seem to be any, strictly speaking, health and safety risk, but the coroner has again decided to do a jury inquest. It's the coroner's discretion. There's obviously these triggers that mean that he has to, or he or she has to, but they can, if they choose to, hold one. And if they do hold one, that makes it longer, more complicated. You have to build in breaks for the jury. You have to do more detailed and complex submissions so that everybody's clear. And then they have to go away and they have to make the determination. So a jury inquest does make things more complicated and take longer.
Yeah, certainly. Just touching upon that, Callum makes a really good point there. Jury inquests, generally an Article 2 may trigger a jury inquest. They tend to be longer, as Keller has said. A standard inquest, maybe a day. An Article 2 jury inquest, you might be talking about certainly a week or 2 weeks, because they tend to be more witnesses being called. But in terms of the jury questions, again, they are addressing those statutory questions. The coroner will address the jury in terms of the law and the procedure, and it's for the jurors to decide to address those 4 statutory questions. But I will address, obviously, when we come to the slide on conclusions, in terms of the scope in which a jury, what types of conclusions would be available for the jury to address. So if I can just move to the next slide in terms of witnesses at the inquest. I know Keller touched upon this already, so I just wanted to touch upon more some of the procedural issues arising from witnesses at inquests. It has to be remembered that witnesses being called on behalf of a organisation are there to assist the coroner. They are not personally on trial. They're there to assist the coroner on factual matters. It is really important that they provide evidence, factual evidence in relation to matters within their own knowledge and belief. They don't speculate, they don't go outside their remit, which comes back to the question or the issue that Keller raised in terms of having the right evidence in the first place. If you don't have the witnesses there, they may well be asked about things outside their remit, and the question is, are they the best witness to address that? So certainly, generally, I will say to witness, don't offer opinions, comment on things within your own knowledge and belief. There's obviously, again, Keller touched upon it, that support that they would probably need at an inquest hearing. Generally, most witnesses will not have attended an inquest before. Certainly if they're frontline, they may well have attended family courts or a civil court as witnesses, and it is a different process because it's a different process in that you don't have, they will be questioned, and the process really is the coroner, because it's the coroner's court, it is an inquisitorial process. The coroner will initially ask questions of the witness. So statements will be provided in advance. The coroner will try to elicit or clarify issues in terms of taking out relevant questions arising from that evidence to allow him to assess or bring out factual evidence to allow him to address that how question. After the coroner's asked questions, there are opportunities for interested persons to actually also ask questions. And they can ask questions. So the family members could ask questions, whether they're represented or unrepresented. They are entitled to ask questions. If they are more than the family members there, other interested persons can ask questions. Your own representative will be in a position to ask questions, but really just to clarify matters at the end. So sometimes you may think, why has my own representative not asked questions? Because they probably don't. You've answered everything they need to. The only likelihood is where your own representative would ask questions is to actually clarify an issue that you may have, some evidence that you may have given, but it's probably not come out in the right way. So generally, in terms of inquest process, it is an important, witnesses are the key to providing an organisation's evidence at an inquest. They play a really important factor in terms of the next slide that I want to address in terms of conclusions. So in terms of conclusions available to the inquest, these are generally split between, on my screen, it's on the left, which is short form conclusions and what we call narrative conclusions. The Chief Coroner has detailed in many guidance legal notes and guidance notes that it's preferable for coroners to provide short form conclusions. So the types of short form conclusions could be industrial disease, unlawful killing, road traffic collision. That is effectively what a short form conclusion is. Standard Jameson inquests will tend to, the coroner will tend to adopt a short form conclusion. A narrative conclusion is more detailed. So again, it's a more detailed explanation as to the circumstances. As it says on the second point there, certainly the option available in narrative conclusions is it allows the coroner and the jury to be judgmental. So you know, I know Keller and I have said, well, the process is not to attribute civil or criminal responsibility. How do you weigh that up with the ability to provide judgmental conclusions regarding the circumstances of the death?
One recent conclusion that I had on one of my inquests was the coroner made the comment that a certain process was less than optimal. So it's not directly critical in the same way as a civil court or a criminal court would be, but a coroner saying less than optimal is not ideal.
Yeah, so the chief coroner's guidance, Keller, kind of provides what judgmental conclusions can be. So you're right to say, it says that any judgmental narrative conclusion shouldn't adopt civil liability. So they can't use words such as negligence, breach of duty, or carelessness. But what they can permit, and what the guidance suggests, is permitted judgmental words, and this is straight from the guidance, says they're allowed to use words such as inadequate, inappropriate, insufficient, lacking, unsuitable, unsatisfactory, and a failure. I leave it to yourselves to weigh up whether that sort of errs on the side of, does it actually, is it slipping into the territory of whether that's attributing a civil blame? So that is where it's really a blurred, the conclusion is really, really important.
It is a blurred line, and particularly when you get a coroner making comments about failure, the automatic mindset is to go from failure to there has been negligence because there has been a failure.
Yeah.
That often will lead to and prompt a civil claim because of those comments. Now, it may still be that you have a defence to that civil claim, but the mere use of that language prompts from the deceased family or their representatives a thought, well, there's been a failure, therefore there must be a civil claim here. So often that language leads to that process.
And can I just, final point on this slide, just address that actually as a representative, as an advocate at the coroner's court, interested persons surprisingly can't address the coroner in terms of the facts. It's the coroner's remit to address, distill the facts from the evidence he's here. So as an interested person, you can't actually address the coroner and say, well, you've heard the evidence, you should be making a finding this way. You can't address the coroner in terms of his conclusions. You can address him in terms of the law, but not in relation to the evidence or the facts. And that just brings me on to the final slide in terms of Regulation 28. I know Keller touched upon this. It is a arm sort of available for coroners to deal with. They can issue following an inquest, or even possibly even before an inquest, a report to prevent future death. It is a published document, as Keller has said previously. It is published on the Chief Coroner's website. So both the the coroner's concerns are reported, and any response is provided as well. There is pretty much tight deadlines to provide a response. So normally they are issued within 10 days of an inquest, setting out the coroner's concern, and a response has to be provided within 56 days. What the coroner can't do is tell an organisation of what to do about those concerns. They simply raise the concern, and it's up to the organisation to address that concern in a response. So one other aspect of Regulation 28 is there's no way of enforcing that. So if an organisation or an interested person doesn't respond, there's no sanction applied to that. But certainly for public bodies, I would never recommend that you do not respond to a Regulation 28, because it is a public document. It is it's in the public domain, and it's important from a market, from a public perspective, that it's out there. Generally, if a Regulation 28 is publicised, there may well be some media attention regarding it. That's an important consideration. It's your opportunity as an organisation to also address some of the factual issues arising, having regard to the point I made that you can't address the coroner in terms of the facts. So your Regulation 28 response is the opportunity for you to be able to address that.
That brings to mind, Rids, one you dealt with recently, where we were instructed, I think 4 days before the inquest, with one witness, and it became clear that evidence from an additional 1 or 2 witnesses would have assisted, but you couldn't get that in before the coroner. A prevention of future death report was issued, but had those witnesses been in place, the clear factual position would have been there and no prevention of future death would ever have been received. So you then had to do a response clarifying those points after the event. Hence the reason why it's so much better to get that information before the coroner at the right stage, because if you get it in public, you then have to rectify an inaccuracy on the facts.
Completely. And it comes back to the question that, again, a slide that Keller dealt with, it's the duty of candor. If you've addressed an issue, you've addressed a potential failure or a matter that you need to improve, and you can present that to the coroner, you can probably persuade the coroner that there's no need. But can I say the actual bar, the threshold for a Regulation 28 is fairly low, and that's really following the London bombing inquiry. The actual bar is really, really low for concerns to be raised. So I don't necessarily see it as a trigger for a civil claim. It generally is, but even if a Regulation 28 report is issued, there is an opportunity for an organisation to actually respond to that. When the slides, I'm not going to deal with, you can probably see from the right, the column there, 60 new PFDs issued in November alone this year. So, certainly Health Service receive many reports, but that's another topic altogether. I'm mindful that obviously we're just running up to time. And we did promise to come back
the answers.
Yes. So question 1, we've got really good results here. So question 1, 100% everyone's correct there to establish the cause and circumstances. So correct there. Who normally conducts an inquest? Number 2, again, no questions there. Exactly correct, a coroner. Number 3, in which situations is an inquest usually required? And the correct answer is when a death is B, when a death is sudden, unexplained, or suspicious. So
I think it's worth saying, though, interestingly, from the person who said dies while travelling abroad, that an inquest would take place, but it would take place in the jurisdiction where the person died, which you're well aware of, with one having done several multi-jurisdictional inquests.
Yeah, and actually, well, it's actually if a death abroad takes place, but the body is buried within an area within the UK, and where within the UK, then an inquest would take place. And just on that point, I did deal with a foreign death, and believe it or not, that inquest is still going on 10 years on, because there's ongoing criminal proceedings. So it can take, the inquest would generally be stayed pending any other parallel proceedings. What question?
Going to the next question, we've got a quite a broad range of answers. Can an inquest result in a civil or criminal charges being filed?
Yes, go on. You want to address that?
The inquest doesn't result in charges or claims being filed. They can be, but they're done by a different area. So if the police think there are grounds for a prosecution, there can be criminal charges. We've both dealt with several inquests over the years where there's been a criminal trial going on in the background, and the inquest has to wait until those are concluded.
So the answer's C. So it can provide evidence for further investigation, essentially. Number 5, what's the role? Again, a bit of a mixed bag there in terms of answers. The correct answer is B, to assist the coroner in determining the facts of the case. Number 6, which of the following outcomes can an inquest deliver? The answer is C, a short form or narrative conclusion describing how the death occurred. And very, very quickly, mindful of the time, number 7, are witnesses required to attend an inquest? The answer is B, yes, if they are summoned by the coroner. And the final question before I leave you is, can family members participate in an inquest? And I think everyone generally got this correct. Yet it's B, yes, they can provide evidence and ask questions through legal representatives or themselves if unrepresented. That's really the time up. Thank you for joining us today. We will send out the slides, so thank you from me.
And have a very Merry Christmas, and thank you for joining us.
Thank you.